Hello, where is she?
I don't know, Your Honor. I visited with her in jail. I sent her notice of setting. She apparently got out on bond.
Welcome back to Court Stream, where real justice meets real drama. Today we dive into a jaw-dropping courtroom roller coaster featuring none other than Judge Boyd, the no-nonsense, sharp-tongued judge who's earned a reputation for cutting through excuses like a hot knife through butter. And trust us, this case has it all. Missing defendants, courtroom no-shows, emotional pleas, deflected blame, and a whole lot of late arrivals. Our spotlight is on Samantha Venegas, a defendant who seems to have mastered the art of tardiness, confusion, and contradiction. But as you'll soon see, Judge Boyd has zero patience for games. From misplaced house keys to slow walking in the wrong shoes, Venegas throws out excuse after excuse, and Judge Boyd isn't having any of it. But it's not just about courtroom etiquette. This case spirals into something much bigger. We're talking major drug charges, possible life sentencing, emotional breakdowns, and a moment where even the judge has to remind the courtroom that this isn't about feelings, it's about facts. Along the way, you'll witness raw human drama, legal pressure points, and a powerful reminder of how decisions, both past and present, shape your future in the justice system. You'll also get a front row seat to legal maneuvers, plea deals, and a defendant trying desperately to convince the court, and maybe herself, that she's ready to change. So buckle up. This is more than just a courtroom. It's a collision of choices, consequences, and cold, hard truth. Let's get into it.
I don't know where she is. I called her in the hallway.
All right, just give me 1 second.
I made an announcement, Your Honor, and she is not in the hallway.
All right, this hearing was scheduled at 9 a.m. It is now 9:40 a.m. The court called the docket at 9 a.m. Ms. Venegas did not answer the docket. Deputy Laura, did you make an announcement for Ms.?
On thin ice, after nearly 40 minutes of waiting, no sign of Samantha Venegas. In court, that's not just inconvenient, it's seriously damaging. The judge mentions a bond forfeiture, meaning, if you're out on bond and don't show up on time, your freedom becomes instantly fragile. The tension is real here. The court clearly made every effort. Dockets were called. The deputy announced her name, and still no response. The defense can't even confirm recent contact. Not a good look. Do you think someone in this position deserves a second chance? Or is not showing up just digging a deeper hole? Here's the legal kicker. By not appearing, Venegas puts her bond status in jeopardy. If she doesn't show up again, she risks being remanded without bond entirely. Judge Boyd isn't bluffing. It's a brutal reminder that in the justice system, showing up is the bare minimum. And when you don't, the system moves on without you.
Villegas?
Yes, Your Honor, I did. She is not in the hallway.
All right, defense, have you had contact?
Not recently, Your Honor. I letters, yes, but because the letters didn't come back.
All right, state.
State's requested a bond forfeiture.
All right, that will be granted in each case. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Yes, ma'am.
All right, thank you.
Be excused.
Yes.
Thank you.
All right, why were you late?
I couldn't find my house keys. Step out to the front. Mike. Oh,
Speak loud so she can hear you.
I couldn't find my house keys, madam. I just ended up leaving the house unlocked.
You heard that right. She was late to court because she couldn't find her house key, so she just left the house unlocked. Let's pause. First, this is a courtroom, not a casual appointment. Showing up late is bad enough, but offering up an excuse that sounds like it came straight out of a sitcom, that's a bold move. Judge Boyd's reaction is priceless. Calm, cool, but dripping with disbelief. Probably need to find the keys. The subtext? You're 44 years old. This is unacceptable. Do you think this kind of excuse would fly with your boss? What about in court, where your freedom is on the line? This moment is the perfect blend of legal seriousness and sheer absurdity. It's almost comical, but the stakes are deadly serious. Because missing court isn't just rude, it's risking jail. And Judge Boyd is rapidly losing patience. If you're in court, bring your ID, your documents, and yes, your house key.
All right. All right. Probably need to find the keys. All right. Then we'll go back on the record. The court is recalling 2024 CR 008054 and 2024 CR 008052, State versus Samantha Venegas. Could I have parties announced for the record?
Jason Garrett for the state, Your Honor.
Denny Callahan.
All right, and you're Miss Venegas?
Yes, ma'am.
All right, the court had entered a bond forfeiture and remain without bond at 9:40 because the defendant was not present. Any objection to the court recalling that order? State? And defense, I'm assuming you have no objection.
Oh, Your Honor.
All right, that will be recalled. Where are we on discovery?
This part signals a legal reset. The court decides to recall the previous bond forfeiture order, meaning Samantha just dodged a huge bullet. But this isn't a win. It's a second chance she's lucky to get. Now we shift to the legal engine, discovery. For those unfamiliar, discovery is when both sides exchange all the evidence they have. It's like showing your cards before the trial begins. And here it sounds like they're close to a deal. The court's request for a 30-day plea deadline reset tells us negotiations are still ongoing. But this is a soft warning. The clock is ticking. Should someone who's been repeatedly late still get more time to cut a deal? Or should the court push harder for trial? This is where justice becomes strategic. Deals are made in these quiet reset moments, but one more no-show, and this delicate balance can collapse. Judge Boyd knows it.
We have everything, Your Honor. We're getting closer to an agreement. I suggest one more reset. Plea deadlines reset.
All right, Ms. Ferguson. Can I have a 30 days reset for plea deadline date? All right, we'll be back on October 24th. Once you sign the reset form, you will be excused. Thank you.
Thank you.
All right, why were you late for court?
There's no, there was no excuse really. I mean, the excuse that I have is, it was a stupid excuse because I wore
No,
the
what's
wrong
your
shoe-
stupid excuse?
I wore the wrong shoes and I was walking really slow because I didn't want to fall. And I shouldn't have worn these shoes.
This excuse deserves a slow clap. Wrong shoes is equal to court delay. Judge Boyd's face says it all. She doesn't even raise her voice. She just breaks it down piece by piece, like a school principal explaining why the dog-eating homework line doesn't cut it anymore. The judge even checks her age. How old are you? 44. This isn't about shoes, it's about accountability. Let's be clear, showing up late once is a problem, but twice, with excuses that sound like punchlines, that's just poking the judicial bear. And when Judge Boyd reminds her of the previous bond forfeiture, it's not a threat, it's a flashing red light. Do you believe Venegas is just unlucky, or is she treating the courtroom like it's casual? This moment is peak Judge Boyd, part courtroom, part tough love TED Talk. But the message is clear: grow up, show up, or go back behind bars.
Okay, so here's the thing. This is what you have to understand.
Apologize.
This is what you have to understand. How old are you?
I know I'm 44, ma'am.
All right, you're 44. On September 24th, there was a bond forfeiture issued for you because you were a no-show and you came strolling in at 9:40 a.m. And at that time, it was recalled. Your attorney came back and it was recalled and you're late again. Do not be late for this court again. Do you understand?
Yes, ma'am.
Judge Boyd drops the gavel figuratively and verbally. This warning isn't just courtroom protocol. It's a final boundary being drawn in bold red ink. You can feel the shift. Her patience has hit its limit. One more late appearance and it's straight to custody. No bond, no delay, no excuses. This moment is a wake-up call. But what makes it even more intense is the way Judge Boyd reframes it. Your attorney isn't the one going into custody, you are. It's a brutal but necessary reminder. No one else can carry your consequences in a courtroom. Do you think Judge Boyd was too harsh, or exactly right? She's not out for blood, she's out for order. And order requires respect of the court, of the system, and of one's own actions. If this doesn't get through to Venegas, what will?
If you're late again, then guess what's going to end up happening? We're going to call it. Your attorney, he's not looking at going into custody, it will be you. You understand?
Yes, ma'am.
All right, counsel, where are we on these cases with discovery?
No problem. We're finished with discovery, Your Honor.
Okay. State, were you able to tender an offer?
Yes, Your Honor.
Yes, Your Honor, last time.
Okay.
My mistake, Your Honor.
All right. So, we were here and I do see that the offer was tendered and we were coming back today for a plea deadline date.
I believe it's correct, Your Honor.
All right. So are you asking for a jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date. It's a drug case. It should be fairly short. How much time do you think?
2 days, maybe.
2 days, maybe. All right, your jury trial is November 12th. If you are not on time, a warrant will be issued. Do you understand? Unless there's good cause.
Let's talk about stakes. Judge Boyd just set a crystal clear boundary. If Samantha Venegas is late to her trial, she will be arrested, period. There's no will reschedule. No try again tomorrow. This is the legal equivalent of a strike 3 warning, mistrial, and a warrant goes out immediately. Why does this matter? Because we're not talking about some minor infraction here. This is a drug case, estimated to last 2 days, fast-paced, high-intensity, and full of consequences. And given her history of showing up late with flimsy excuses, this warning carries serious weight. Should judges issue warrants for trial no-shows immediately? Or should there be some grace if they've been compliant recently? Judge Boyd's tone tells us she's not making empty threats, she's managing chaos. And in her courtroom, showing up isn't just encouraged, it's enforced with steel.
All right, thank you. All right, once you sign the reset form, you are excused.
Okay, thank you.
Thank you.
Thank you.
All right, everyone, I'm going to call the docket. So when I call your name, you need to stand and let me know you're here. If you don't answer or stand, I'm going to assume you're not here and a warrant may be issued for your arrest. Samantha Venegas. Oh, look like we're going to have a busy day. All right, Samantha Venegas.
Here. May I address the court?
Yes.
Ms. Venegas would like to hire her own attorney.
All right. Then you'll need to be back here this afternoon.
Well, I didn't mean like hire one right now, ma'am. I feel even if I get another court appointed attorney, I feel I don't feel like he just wants me off his case. So that's how I feel. And he hasn't done nothing for me.
Well, let me
to
just
help
tell
me.
you, let me stop you right there.
Yes, ma'am.
So in this cases, it's sort of like in sports. We shouldn't be dealing with feelings. We're just dealing with facts.
Mike, drop. Judge Boyd cuts right through Samantha Venegas' emotional claims like a hot knife through butter. He doesn't care about me. He hasn't done anything. But here's the thing. Courtroom justice isn't built on feelings. It's built on evidence, deadlines, and facts. And Judge Boyd, who's been both a defense attorney and a prosecutor, makes it abundantly clear your attorney doesn't have to coddle you. They have to represent you. This moment is pure gold. It pulls back the curtain on courtroom expectations. You don't get legal sympathy just because you feel ignored. The system is built to function, not to validate emotional turbulence. Have you ever felt unsupported by someone doing their job technically right, but not emotionally involved? In legal terms, doing their job is enough. And Judge Boyd once again brings it home with fire and clarity.
These are the facts. And I'm speaking to you from a person who's been a defense attorney and a person who's been a prosecutor. Sometimes we want our attorneys to be touchy-feely. We want them to sit down, walk us through everything, hold our hands. There are some attorneys who will do that. There are some attorneys who will be your secretary. They will get your calendar together for you, call you and say, remember, you have a court setting, please be here. Other attorneys, they don't do that. Now, what I can tell you, your attorney has no duty to call you and tell you there's a court setting unless they change your court setting. Otherwise, everybody knows when their setting is. With your cases in this court, I require that your attorney receive all discovery. He's received all discovery. Then I require that the state give an offer. State has tendered an offer. You can either accept it or reject it. here's the thing, your attorney can't force the state to give you something that you want. If you want your case to dismiss, your attorney can present information to the state the reason he thinks it can be dismissed. They still can say, yeah, we're not dismissing it. This is what we're offering. That's where we are. So we will have you back here at 1:30.
Thank you.
You're welcome. And Ms. Venegas, you were late for court. You were late for court today. Don't be late coming back. All right, Samantha Venegas. Hello. Okay, all right, you're gonna come back here tomorrow and we're gonna have a jury brought up. And whoever, if you decide to hire an attorney, you need to let them know they need to be prepared and ready to go to trial tomorrow. All right, Ms. Ferguson, if you'll give her a reset form for tomorrow, please. All right, thank you. Thank you, Mr. Callahan. All right, I'm gonna call the docket. When I call the docket, you need to answer and let me know you're here. Samantha Venegas. Samantha Desiree Venegas.
Yes, Your Honor.
And she's on bond, correct? All right, it's the court's understanding that you wish to have a bench trial? And you understand what all of that means?
Yes, ma'am.
Okay. State, on this bench trial, how long do you think it would take?
In after 2 days.
Well, it's a bench trial. We have 4 or 5 witnesses, Your Honor, and that's including the drug analyst? Yes. Okay.
All right, so do you all want to confer with Ms. Ferguson when you all would like to do the bench trial?
Sure.
All right, so if y'all would confer on a date, so we won't do your case today since it's going to be a bench trial. Your attorney in the state will confer with the coordinator to see what's the date that works best for everybody involved, okay?
Thank you, ma'am.
All right, and then Norma, if you could see if we could perhaps do this before the new year, if possible. Samantha Venegas. All right. All right, Deputy, could you make an announcement for Samantha Desiree Venegas? Thank you. And counsel, I do believe that the bondsman may have filed an affidavit to surrender surety. I'm unable to check because the system is down. We're going to go on the record. Court is calling 2024 CR 008052 and 2024 CR 008054, State versus Samantha Desiree Venegas. Could I have parties announced for the record for the state?
Andrew Harris, Sadelman.
Defense?
Denny Callahan, not ready, not present.
All right, so this hearing was actually scheduled for an agreed bench trial today. Deputy? She hasn't made it back. The court is aware that I believe an affidavit to surrender surety was filed. Is that correct?
I don't know, Your Honor.
Okay. The court is unable to check due to the system Odyssey being down. Deputy, did you make the announcement?
But he answered outside, Judge.
All right, thank you.
You're welcome.
All right, State, what are you requesting?
Grant the affidavit of surety to surrender issue the apprehension. And
All right. And again, the court believes an affidavit to surrender surety has been submitted, but our systems are down throughout the courthouse, so I'm unable to check.
Your Honor, I apologize for interrupting. If there is an affidavit of surety to surrender, then grant it.
Okay. So what I'm going to do is I'm going to issue a judge's warrant and remand her without bond.
Yes, ma'am.
Boom. It finally happens. After multiple warnings, missed appearances, and legal resets, Judge Boyd lowers the hammer. A judge's warrant is issued. Samantha Venegas is now officially remanded without bond. No bail, no free pass. just a cold, hard consequence. And this isn't a spontaneous reaction. It's the result of repeated failure to comply. Even the courthouse systems are down, yet Judge Boyd moves forward, because delay after delay has already cost the court enough time and trust. The context here matters. A bench trial was supposed to happen today. That means witnesses were likely coordinated. Time was blocked, people showed up, and the defendant, MIA again. Do you think remanding without bond is too harsh here, or completely fair after everything we've seen? At some point, the justice system has to say enough is enough, and Judge Boyd does just that.
All right, is there anything else, counsel?
No, Your Honor.
All right, you're excused.
Thank you, Your Honor.
Okay, I'm gonna do that.
Yeah, approach, Your Honor.
He said Project Hail Mary. Yes,
Yeah, approach.
yes. Yes.
Venegas says she's in the process of hiring Charlie Bunk. Bunk is tied up in another matter, that's why he's not here today. So she would like him to represent.
All right. Miss, could I see the file on her, please, Venegas? All right, Miss Venegas, this case has been pending since September, so we're going forward with this trial. All right, we're proceeding. All right, thank you. All right, the court is calling 2024 CR 008052 State versus Samantha Venegas. Could I have parties announced?
Andrew Harris, Salem for the state.
Benny Callahan defense.
And are you Miss Venegas?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count 1 and the habitual offender enhancement allegation.
Any objection?
No objection.
Did you understand in count 2? You're charged with the offense of possession of a controlled substance, penalty group 1. Let me see here. Less than 400 grams. Did you understand? If you have a plea bargain agreement, I'm sorry. Now it's 400 grams or more. So you're charged in count 2 with possession of a controlled substance, penalty group 1, 400 or more grams. Did you understand? Did you understand the range of punishment for the offense for which you are charged is anywhere from 10 years to 99 years or life in prison?
Let's take a moment to breathe, because this line changes everything. Judge Boyd calmly lays it out. Samantha Venegas is facing a sentence that ranges from 10 years to life. That's right, life in prison. This isn't traffic court. This is serious felony level time, and the court is making sure Venegas knows exactly what's on the table. The substance in question, over 400 grams of a controlled drug, enough to bring down life-altering consequences. It's not just the amount, it's the implication. Drug possession at this level screams distribution, intent, and organized activity. And when the state opposes deferred adjudication, it means they're not buying the "I didn't know" defense anymore. If you were the judge, would you still consider probation for someone with this kind of record and drug volume? This is a case teetering on the edge, and Judge Boyd isn't going to sugarcoat a thing.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 99 years or life in prison. And also the range of punishment is up to a $10,000 fine. And did you understand that the court could sentence you up to a $10,000 fine as well? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on count 2. They're asking that your punishment be assessed at a cap of 15 years in the prison. There's a $2,000 fine. The state is opposed to your application for community supervision or deferred adjudication. They're taking into consideration 2024 CR 008054. Did you understand that to be your plea? Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Judge.
Then to count two in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Be contained in exhibit 1 and attachments, Judge.
No objection.
All right. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. And after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. So we will come back. We can go off the record. We will come back on May 13th. On May 13th, I'll make a decision on your application based upon whatever evidence is presented to me. So I'm going to order a PSI and a TAP evaluation. The TAP evaluation is really to see whether or not you have any controlled substance issues. All right. Do you have any questions about anything? All right. So I've given you a reset form because in case you release, you'll still know that you'll need to come here and it'll be at 9 a.m. Do you understand? All right. Thank you.
Judge, may I approach?
Yes. State versus Samantha Venegas. Could I have parties announced?
Jason Garrett, half from the state, Your Honor.
Denny Callahan, defense.
And are you Miss Venegas?
Yes, ma'am.
You entered a plea to count 2 on March 26th. You entered a plea of no contest. According to your plea bargain agreement, punishment is to be assessed at a cap of 15 years in the prison. There's a $2,000 fine. State opposes your application for community supervision and deferred adjudication. They're taking in consideration 2024 CR 008054. All right, the court will hear argument. Well, before I hear argument, there are some things that defense, maybe you can address with the court. It says in the PSI that her guilt is minimized. And I did read where she's saying that the vehicle's not hers. She knew there was drugs in the trunk, but she didn't throw them away. She didn't do anything about it. So I don't know if there's any insight you would like to give on that.
Yes, Your Honor. I think it's a good inference from the stipulations and the PSI that she was used as a pawn, taking advantage of her poverty and her addictions to methamphetamine. And she's ashamed of that in her life, not only you, but more particularly to her family. There is an element of voluntariness in her actions. There's also an element of being trapped in her actions. And that was one of the things I would ask the court to consider before you assess punishment. I have 3 other remarks.
All right, you may proceed.
And I suggest to the court as a proper resolution of this case, because she's still relatively young, deferred adjudication, 10 years, ISF treatment, and she asks you to put her into drug court, which is intensive supervision for every day. That shows some indication of remorse and desire to be rehabilitated.
Here comes the heart tug. Defense pulls out a powerful appeal. Rehabilitation over retribution. It's a classic courtroom pivot. When the evidence stacks too high, you turn to remorse and redemption. And here's the strategy. Shift the court's focus away from criminal past and toward a hopeful future. They're not denying the facts. They're begging for a chance to heal. But Judge Boyd doesn't operate on sentiment. She needs to see that remorse isn't just convenient, it's consistent. And that's where it gets tricky. Venegas has a history, a long one, multiple prison stints, repeated parole violations. Her story is compelling, yes, addiction, poverty, shame. But the court doesn't run on stories alone. It runs on patterns. Do you believe everyone deserves one more shot at redemption, even after multiple failures? This is the courtroom crossroad, rehabilitation versus incarceration, and both choices have weight.
All right, so here's part of my issues, right?
Yes, ma'am.
One, I have to look at criminal history. And I would have clients sometimes, you know what they would tell me? Why are people looking at my criminal history? We're just here for this. That was in the past. But I would always tell them that your criminal history is sort of like a credit report. And what you're trying to get is probation. So people are trying to say, has she been placed on probation before? You know, will she do well? So it shows that you've been on probation before. And a motion to revoke was filed and you were revoked and sentenced to 5 years. I know that was in 2007.
Right.
And then in 2014, you were sent to prison for another case. And in 2015, there's a case that you were sent to prison for, and I believe these were running concurrently because it appears that they were running concurrently. And then 2016, again, that's a case. It was running concurrently with the others. So what I'm viewing, it doesn't appear that you would be a good candidate for probation.
This right here is the credibility kill shot. Judge Boyd isn't just reacting emotionally, she's reading the receipts. Probation history. Bad. Revocations. Multiple. Prison time. Served. More than once. You can almost feel the defense team bracing for the impact. And then comes the analogy. Your criminal history is like a credit report. Absolutely savage and dead accurate. Just like bad credit, a long record of legal failures means you don't get the benefit of the doubt, especially not when you're asking for probation again. If someone has failed probation 3 times, should they even be allowed to ask for it a 4th? The courtroom isn't just judging this moment, it's judging a pattern, and Samantha's pattern is consistently self-destructive. Judge Boyd has seen it before, and she's not impressed.
May I say something?
Sure. You want to raise your right hand though, because the state may have some questions if you want to say something. All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Samantha Benavides. I know, okay, I did, in 2010, I went to prison. I was gonna get reinstated on probation, but I took it up with my grandfather, and my grandfather wanted me to go do the time instead of being reinstated on my probation, because he was scared that I was gonna get messed up again and go do a large number of time, and he was gonna pass away.
And
while I
how
was
old were
gone.
you when that happened?
I was 29, 30. And so that's why I chose that. I chose that because my grandpa asked me to do that, and he ended up passing away 6 months before my release. But that is why I was gonna get reinstated. At the time, my attorney was William Reese, and they were gonna reinstate me and send me home, but my grandfather asked me to get it over with. That is why I went to prison. the
All
first
right, so you're telling me that I
time.
could understand maybe there being pressure on you with saying, oh, let me listen to my grandfather and take this time. But at the time you were 29, 30. Okay.
Yeah,
And then the other cases, because you got out of prison and then you pick up more cases.
in 2014, I revoked, I have my parole, and I went back to ISF for the last 3 months of my my parole. And then that was done with that. And then in 2016, I went to prison again in 2016. And then I revoked and went back to safety, and I came out and I completed the rest of my probation.
Okay. Why do you keep failing at probation?
Oh, it was parole, the second.
Well, I mean, you
Yeah.
failed at probation and you failed at parole. Why?
The first time, when I was younger, I really don't have, I made some poor choices in my life back then, and I was young, I was ignorant.
But no, for the case that you said the first case, you said, I just agreed to be revoked because of my grandfather.
Yeah.
All right, you're telling me then you were 29.
Yes, I didn't
30.
go report.
All
I didn't go
right.
report, and I
But then
had
you-
a drinking problem back then.
Okay.
And back then I would use cocaine a little, and but I had a heavy drinking problem. So I was young, I was stupid, I was living in the bars, basically.
Mhm.
And I wasn't, keep out there running the streets or nothing like that. I just didn't want to go report. And that was my biggest downfall right there. If I would have went and reported and went and taken a UA, everything would have been okay. my life would have been a little bit, different. The other time, when I got out, I violated parole, it was because I came out of dirty UA.
Okay, let me ask you this,
Okay.
because I understand your past. Do you know the amount of drugs this was, the weight of it?
Yes, ma'am, I do.
It's a lot, right?
Yes, ma'am.
Okay, you can continue.
My life, for a while, I was just, I made a lot of mistakes and I'm not proud of it. I'm very sorry for them. If I could take them all back, I would. Now that I'm older, now that I see things differently, and trust me, this opened my eyes. I was doing a lot, I was. I was just trying to, this last offense. I was something, it was just, I was trying to, get by, pay my bills. I was stuck in it. I was just trying to get out of it. And I see now that what it cost me, what it could cost me. And I apologize for that.
No, but here's the thing, you had a previous drug case.
Yes, ma'am.
So I don't understand why you continue to try to build your happiness off somebody else's misery. And when you sell drugs, that's basically what you're doing. You're taking a shortcut and you're building your happiness off somebody else's misery who has a drug addiction and can't stop. And there you are giving them drugs for money.
Correct, you're right.
All right, State, do you have any questions?
Just facts of this case.
Okay.
Ms. Venegas, on this case, you stated that the drugs weren't yours or the drugs were somebody else's.
It wasn't mine, it was in the vehicle.
All right, could you speak up, please?
It wasn't mine, it was in the vehicle, but I was aware that it was in it, and I should have gotten rid of it.
So you're
When I-
aware,
when I
though, you had a
located it.
key in your pocket that matched the lock to the box that the drugs were in, correct?
Yes, correct.
Okay, no further question, John.
Well, there goes that it wasn't mine. Defense. When the key to the locked drug box is in your pocket, you're not just aware of the drugs, you're in charge of them. That's the smoking gun moment. The evidence that turns suspicion into certainty. Samantha tries to tiptoe around it. They were in the car. I didn't get rid of them. But intent doesn't need a confession when the key is literally on your person. That's direct possession, plain and simple. Judge Boyd, sharp as ever, sees through it. She knows when someone's trying to downplay their role, and she's not letting this slide into victimhood. At what point does I was just around it's become I was responsible? Would the key in her pocket be enough for you to convict? This is the moment where any reasonable doubt vanishes.
Nothing further. I have one other point, Your Honor.
Yes.
She has family support and was unable to get finalized letters into your hand indicating that support. That's all, Your Honor.
All right. Ms. Venegas,
Yes, ma'am.
the amount of drugs in this case
Yes, ma'am.
is, let me see, over 400 grams.
Yes, ma'am.
And from what I read in the police report, you're a seller of drugs. And this whole thing about the drugs being in your boyfriend's car and you don't know, you knew the drugs were in your boyfriend's car and you should have got rid of them, but you didn't.
Yes,
It doesn't ring true based upon what I read in the police report, because according to the police report, you're known as a trafficker of drugs. That's what it says in the police report, and that's what was stipulated to. I don't think you're a good candidate for probation. The court is going to find you guilty. The court will sentence you to 15 years in the prison. There's a $2,000 fine. Time and money will run concurrently. The court will take in consideration 2024 CR 008054. I'll suggest the therapeutic community. All right, good luck to you.
May I address the court? She would
Yes.
like drug therapy.
All right, I'll add the therapeutic community.
Yeah. One more thing, Your Honor.
Yes.
Would the court entertain a delay in imposition of sentence 1 week and let her go and take care of her affairs?
No.
Thank you, Your Honor.
All right, thank
And there it is. The gavel drops. After months of delays, missed court dates, emotional pleas and last-ditch defenses, Judge Boyd issues the final ruling, 15 years in prison, a $2,000 fine, all charges considered. No more extensions, no more second chances. The courtroom falls silent, because the weight of that sentence isn't just legal, it's life-altering. Venegas faced charges tied to serious drug trafficking, over 400 grams, key evidence literally on her, and a long criminal history to match. Despite her emotional testimony, her family's support, and a plea for drug court, Judge Boyd ruled based on what the evidence and history demanded. It's a sobering reminder, the system isn't cruel, but it is consistent. The past doesn't disappear. And when your actions stack up like this, justice doesn't flinch. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. New cases drop weekly, and trust us, you don't want to miss them. Join the conversation in the comments. Was this ruling fair, or do you think 15 years was too harsh?